Good afternoon, everyone, and welcome back to our video series where we discuss everyday legal topics with TLR Law. TLR Law makes law accessible for the average Canadian, and part of the services they provide includes protecting the rights of beneficiaries. Most of us will be an executor or beneficiary at some point in our lives. As trustees, executor owe many duties. These duties are owed to the beneficiaries of the estate, and they're enforced by the courts. So today we're going to be talking about an executor's fiduciary obligations to beneficiaries. My name is Adam Dooley. I'm your co-host here today, along with Philippe Richet, principal lawyer, co-owner, and all-around good guy with TLR Law Office. Hey, Philippe.
Hi, Adam. I'm glad you think I'm an all-around good guy.
Well, you know, not all lawyers qualify for that, right? So I have to qualify that.
Yeah, that would be exemplified by all the lawyer jokes out there, yeah.
Exactly. So why don't we start with the basics here, Philippe? What are beneficiaries entitled to, and do executors ever double as beneficiaries?
Right, good questions. Beneficiaries don't exist only in the realm of estates. Beneficiaries are people who benefit from a trust, essentially. So when somebody passes away, their estate, their things, their assets fall into this trust, and this trust is managed by an executor or an executrix, and they manage it on behalf of the beneficiaries. So the beneficiaries are the rightful owners of the estate once the debts are paid. So what's left over goes to the beneficiaries in the way that the executor, not the executor, but the testator set out in his or her will. So, for example, if a testator is mother and father, mom passes away, and then 2 years later, dad passes away, and gives everything to his 3 children in equal shares. Then the beneficiaries are the 3 kids, and each beneficiary is entitled to 1/3 of the estate. So the executor has a fiduciary responsibility, meaning a very heavy responsibility towards those beneficiaries to care for those assets and distribute it in a reasonable time frame. So that's the fiduciary. Just means it's the highest level at law that somebody can be responsible for something. So right. Courts hold people who have a fiduciary responsibility to a very high standard.
Well, and you sometimes hear about beneficiaries suing estates, right? So
yeah.
And the courts will have the power to enforce the law or enforce the will as it was written. Is that correct?
Absolutely. And the beneficiary, what they do is they take a position. They say, look, I have no control over these assets because the legal owner, the person who's managing those assets, is the executor or are the executors. But they're supposed to be doing it for my benefit. And if they're not doing it for my benefit, I don't have a lot of power to manage that. So I'm asking you, Mr. or Mrs. Judge, to force the executor to do the things that they're supposed to do. And that's why that's that fiduciary relationship. That's why it's such a heavy burden imposed on the executor or the trustee in this case, because they have all the power to do the things that need to be done. They're the ones who can withdraw the money from the banks. They're the ones who can interact with the insurance companies. They're the ones who can do the tax returns for income tax purposes. They hold all of the tools, but they're not doing it for their own benefit. They're doing it for the benefit of somebody else, which is in this case is a beneficiary. So that kind of relationship between trustee and beneficiary exists not only in the context of estates, it exists in other contexts at law. So it's a very well litigated. It's this trust beneficiary relationship has been around for centuries. Mm-hmm. So there's a lot of law behind that, and courts will hold executors on a very tight leash. They have to be doing everything in a reasonable fashion for the benefit of the beneficiaries. So when an executor isn't doing those things, then beneficiaries can request through the court system, can ask a judge to force an executor to do something. And to answer your earlier question of can those two roles double up? Yeah, they do all the time. Okay. We do a lot of wills It's not reasonable to ask somebody to appoint a complete stranger to manage their will as executors for the benefit of their 3 kids. It makes a lot more sense to appoint one of the kids or 2 or all 3 of the children to manage the estate on their own behalf. So while it is technically a conflict between the executor and the beneficiary, we see that occur all the time, and it's reasonable for it to happen in that fashion.
Right, and we had actually a previous discussion on the role of the executor and why it often makes sense to hire a lawyer to help you with that. And if people are interested in that discussion, you can find it on the TLR Law website, tlrlaw.ca. Well, let's just deal a little bit with, what are your rights as a beneficiary in Manitoba?
Well, you don't have a lot of rights as a beneficiary. I mean, and I should be careful how I say that. You don't have a lot of rights to do something. You have a lot of rights in terms of what you're entitled to receive, and you're entitled to receive your estate or your portion of the inheritance. So in the context of an estate, you're entitled to receive whatever it is that the testator, be it mom, dad, your brother, your sister, your spouse, have decided to give to you under the will, and you're entitled to receive that within a reasonable time frame. That's what you're entitled to. There are certain processes along the way. When you hire a lawyer to assist you through this, we're mandated by the court to send out the very creatively named Form 74AA. This is what happens when you have
the infamous Form 74AA.
Yes. Yeah, not to be confused with Form 16A, which is another form that's prescribed by the courts to. So clearly, not a lot of imagination in the naming of these forms, but it's a form, the 74AA, that goes out to all the residual beneficiaries, meaning those who receive what's left over. So, for example, mom and dad, or mom passes away, dad's already predeceased. She wants to give $1,000 to church, $1,000 to cancer care, and the rest goes to the kids equally. Well, in this case, it's the kids that are the residual beneficiaries, whereas cancer care and the church are specific beneficiaries. So specific beneficiaries are entitled to receive whatever it is that's listed in the will, and that's it. But if you're a residual beneficiary, you get this Form 74AA, and that was developed by the courts to ensure that beneficiaries understood what the responsibility of the the executor is, and to ensure they understood what the role of the lawyer is. So if you print it on regular paper, it's 4 pages. If you do it on 7.5 by 14 legal size, it's 2 pages. And it has Part A and Part B. Part A describes the responsibility of the executor, which is essentially to make sure that they handle everything for the benefit of the beneficiaries. And then it goes in the second part that talks about what the lawyers do, and then it kind of lists all the things that the lawyers do. It talks about how we charge these things. So that's more of a information pamphlet, if you want, court style, that all residual beneficiaries are entitled to receive, and they have to receive that within a very specific time frame after the lawyer has been retained to act for the estate.
Right.
They aren't entitled to see a copy of the will. We make it our practice to send out copies of the will when we send out Form 74AA, because if it's not sent out, a beneficiary can apply to court to receive a copy, or to force the executor to provide a copy.
That's interesting. So you're technically not required to provide a copy of the will. You'd think, as a layperson, I just thought, if I'm a beneficiary, I should be able to see what the will said.
Right, and there are no rules specifically that address that issue. The rule that addresses that issue is that somebody can apply to court under a rule number, and I can't remember, 74 something, to compel an executor to provide a copy of the will. So it can be done. Also, once wills are probated at court, then the copy of the will can be obtained through the court system as well.
Oh, I see. So once it's gone through the probate, then it's a public document.
Correct.
Right. So is it also possible for a beneficiary to audit or kind of have a look at what an executor has done or is doing?
No, not a kind of not in a regulated way. What a beneficiary can do is they can compel an executor to go to court to explain themselves to the court, but they don't owe a reporting duty to the beneficiaries. The duty that they owe the beneficiaries is to make sure they get what they're supposed to get when they're supposed to get it. But there is no specific duty that says, well, I have to, every month I have to account for my time and tell you what I've done and ask for your permission, because the power is within the executor to make those decisions. So that's why it's a fiduciary relationship, because the executor has all the power, whereas the beneficiary really doesn't have any. So if a beneficiary is forced to go to court, and courts understand that that's a big deal, it costs a lot of money, it comes out of the beneficiary's pocket to force somebody to do something. So a court will take a look at that very carefully. So if you are an executor of a will and you're kind of running roughshod over the beneficiaries and not really doing what you're supposed to do, you can be compelled to court, and you'll have a lot of explaining to do at that point.
Right. Well, let's talk about that. That's my next question, actually. When should I, as a beneficiary, seek legal advice?
Again, I'll give you the typical lawyer answer to that, and it depends on the circumstances, right? If there's not a lot of money there and it's taking a while, then it's not really worthwhile going to court if it's a $20,000, for example, inheritance.
Right.
It might be worthwhile, but you're going to be spending a lot of money in legal fees to get that done. Which means that the estate is also paying for legal fees, which means there's less money left over to be distributed. So it doesn't take long for that money to kind of evaporate. It also depends on your relationship with the executor. If the executor's maybe reliable but not the quickest, fastest person in the world, then it might not make sense to go to court to force them to move faster when in 6 months or a year later you'll get it anyways. So really, I think if you feel that, first of all, that the executor is wasting the money, meaning they're spending the money on things that they're not supposed to be spending it on, or on themselves rather than on the estate, or rather than the way the will said, in that case, absolutely, I think it's important to take quick action, because then you have the courts intervene before the money's gone, which is the big concern. So,
it sounds
and
like a
courts
really hard thing to decide, right? I mean, if you don't really have the right to see the will, or necessarily, and you don't really have the right to take a look at what the executor has done, you really kind of have to just be aware on your own, don't you?
Well, you do, but it's always contextual, right? Like, the law doesn't exist; it exists in theory, but it applies to facts and to scenarios. So
Right.
typically, you'll never be in a situation where you don't know the parties. If you're inheriting something, then I'm assuming you know the people involved, or you're able to get some information on the dynamics of the relationships. Because really, what law does is it tries to regulate relationships.
Right.
So if you have reasonable relationships to begin with, then you don't really need the law to regulate that. If you have unreasonable relationships, then that's where the law comes in. So if you have an unreasonable relationship with somebody and you're worried that that person is not responsible, or not doing what they're supposed to be doing, or they decide, we've heard stories of executors deciding that they don't like the way their mother distributed the assets, so they're going to do it differently. Well, that's problematic, obviously. And so if that's the kind of attitude you're running into, then it's important you get legal representation as soon as possible, because this is litigation in its purest sense. And while I often tell people that they should try at different times, they should try navigating the court system a little bit by themselves. I mean, I don't always say that, but I'm kind of a hands-off person, because um, I respect people's rights, and it is supposed to be an open process to the public. When it comes to litigation, you have too much stuff, you have too many rights on the line. I would definitely recommend talking to a litigation lawyer. And we don't practice litigation at our firm, so we would be referring you out for that type of thing. But I wouldn't waste any time on that. I would absolutely hire a lawyer if you have any concerns about the money disappearing, that you should move quickly.
Well, is there a way, I guess, short of going to court, is there a way to push an executor to perform without without taking that step, without going to court?
No. Sometimes it's the threat of court that gets executors moving. So it's the same process. You'd go see a lawyer. The lawyer would send a demand letter saying you're not doing what you're supposed to. You have to do this by a certain date, and if not, we're, watch out. We'll take you to court.
Mm-hmm.
So,
and like you said, these are often very close family relationships too.
right.
It can be very emotional, right?
Yeah, you're navigating a very stressful environment, and especially if it has to go to litigation, then you know that the relationships were not good to begin with. So it can go off the rails pretty quickly. So it's important to move quickly in those situations so that you can protect whatever you're entitled to or whatever can be protected.
Well, it makes sense. So ultimately, what should I know as a beneficiary? Why don't we just kind of round this topic up? Is that if I'm a beneficiary to my parents' will, and I'm not the executor, maybe it's a brother or an uncle or an aunt that's the executor. What should I know as a beneficiary in that situation?
Well, the first thing you need to know is that estates aren't done in a matter of a couple of months. Estates can take 6 months for an estate going fairly smoothly to several years if there's complicated issues in the estate. Just getting a clearance certificate from Revenue Canada, which is kind of the last step, can take months, up to a year to get those. So by the time an estate starts and it ends, you are looking at a fairly long process. So the first thing you should do as a beneficiary is not expect to get your inheritance right away. That takes time. So running off and hiring a lawyer within the first month or two is not a good idea unless you have exceptional circumstances that indicate that this person either intends not to act at all, or to even worse, to not do what the person is supposed to do. Right. And in those cases, you can apply to court to have that person removed as trustee and executor, and you can have someone else appointed, either yourself or somebody else. But that's a process, and you're going to have to prove or satisfy the court that it's not in the best interest of the estate to have that person continue as executor, because courts don't want to mess around with people's wills. If somebody says, I want Adam to be my executor, a court's going to have to say, well, you're going to have to convince me that Adam's not the right guy for this, because clearly the testator thought Adam was the right guy for this.
Right, and likewise, if mom and dad said that Jane is going to get the family cottage, the courts are not going to act quickly to change that.
They're not going to mess around with the will at all.
Right.
If the will says, as long as the will is legal, if the will says that she's getting the cottage, she's getting the cottage, whether you as executor like that or not.
Or whether me as the brother like it or not, right? Yeah, it just doesn't matter.
A testator is under no obligation. The testator can do whatever he or she wants with their money. It's their money. There's no law that says they have to give money equally to their children. They can give it all to their cat if they want.
So your advice probably would be, if you're not happy with what the testator, what mom and dad put in the will, you'd probably be better off spending the money on therapy than on a lawyer. Is that right?
Exactly. I actually think that's excellent advice, Adam. I would think that spending money on therapy 9 times out of 10 is better than spending it on a lawyer.
All right, fantastic. Is there anything else that we should just know as we wrap up this topic for today?
No, I don't think so. I think we've covered most of it. You don't have a lot of tools, so it can be frustrating as a beneficiary, waiting for somebody to go through all the things they have to go through for you to get your inheritance. Sometimes, legitimately, maybe you don't have that close a relationship with the person who passed away, mm-hmm. and you're supposed to receive a fairly good payout. I understand why people don't want to wait, a year, 2 years, 3 years to receive that money, because that money can be put to good use in that family. So, right. There's nothing wrong with a beneficiary wanting to receive their inheritance in a reasonable period of time, but you have to be, patient as a beneficiary is probably the biggest
Sometimes you hear about executors releasing a partial payment as the
Yeah.
estate is being settled. Talk to me a little bit about that. What kind of circumstances would allow kind of an advance payment before everything was actually, um, sealed and delivered at the end?
So once you're satisfied that all the debts or most of the debts are paid, and the only outstanding issue is your income tax return for the deceased, because when the person passes away, you have to do one final income tax return for that person in the year that they passed away.
Hmm.
So what we normally do is we tell people to, we gather all their assets or the deceased assets. We put all the money in our bank account. If there's properties, the properties are sold normally. The money goes into our trust account. And then we have this big pool of money in our trust account. Could be several $100,000, $500,000 or more. Then the only thing that's usually outstanding at that point is the income tax return. And you can talk to an accountant or a tax preparer person who can tell you, well, I anticipate that the taxes at the end of the year will be this much. Then we also recommend that you get a clearance certificate from Revenue Canada that says that protects the executor from Revenue Canada coming back later on and saying, oh, wait a minute, we're reassessing all these years, and there's some extra money that is owed to us. If the executor has distributed all the cash at that point and they have not received a clearance certificate, they could be personally liable to pay that back to Revenue Canada.
Right, which
So
is
we
one of the
always
reasons why they are very careful and slow in
right,
paying out, right?
right. But if you're waiting for Revenue Canada to give the clearance certificate, you're waiting, sometimes that can take 8 months to 12 months. This is on top of having all of the work done prior to applying for the clearance certificate. So it could be a year and a half by the time the estate starts, and executors don't necessarily want to sit on that money during that period of time. We do have clients from time to time that instruct us not to distribute any money until everything is finalized, which is fine. Those are the instructions. We leave the money in our trust account pending that to be done. But most of the time, what we'll do is when most of the stuff is settled and we're only waiting on CRA, we'll usually recommend that clients hold back in the account a certain amount of money. It could be $10,000, $20,000, enough of a buffer there if there are any surprises that there's money. And then they take the balance, the majority of the money, and do an initial distribution.
Right. Right, that makes sense. Okay. Well, that's very useful.
So that the money can flow out within 6 months, usually, depending, give or take a few months, for the initial distribution, where the majority of the estate is paid out, and then we reserve some money left over. There could be other circumstances where we hold back more money. It really is it depends on the specific situation.
Fantastic. Well, thank you for your knowledge again, Philippe. You're always such a very knowledgeable person on these things, but I suppose that's what we expect when we talk with our lawyers. So to our viewers today, thank you for watching. Please bookmark and share this. If you have a topic that you'd like us to talk about in the future, send it our way. You can contact us through the TLR Law website at tlrlaw.ca. Also, just wanted to mention briefly that TLR Law is hosting a legal workshop for business owners on September the 23rd. And business owners will be able to walk away with lots of information and practical templates for documents, including for employee contracts, guidelines for employee policies, anti-spam policies, and more. Philippe, did you want to just add anything to that about the workshop?
Yeah, this is all part of that concept of not being stupid. There's a lot of things in our business that we can't control, like we don't know what the economy is going to do. As business owners, we know what it's like to be thrown around by economic situations. But there are things you can do to solidify your base, protect yourself. One of the biggest areas of litigation, and one of the areas I find employers know the least about, is employment law and employment contracts. There's a lot a business owner can do there to protect their business, and very few business owners do it. So and that's getting a proper employment contract in place. So that's something that I like spending time on with the small business owners. Save yourself $50,000 in an employment litigation by having a proper. Now, that's kind of clickbait, I understand, But it can be. I've seen, I've been in a situation before where I couldn't terminate somebody because it would have cost me $60,000, and I had a small practice at the time, and I couldn't afford that. So
Yeah.
you end up staying stuck with employees you don't really want to be stuck with, but you don't really have a lot of options. The other areas that can be problematic and they're becoming more and more problematic, is the area of privacy. The federal government is looking at amending our privacy legislation, and it's going to look a lot more like the European one, with some pretty stiff penalties.
Mm-hmm.
And anti-spam laws. They've been in place now, and companies, small, large companies, have been hit by those, and those are substantial fines. And those are avoidable. You can be not stupid in those areas.
Don't be stupid. Just follow the rules, and it makes life way easier. So,
Yeah, and
well, that's fantastic. Go ahead. Sorry.
I was just going to say, there are things that are fairly simple to do internally that you can do to fix those.
So that's September the 23rd. You can register on the website at tlrlaw.ca. I also wanted to just encourage you to like us on Facebook or on Instagram. Just search TLR Law. You'll find us there. And also wanted to close by reminding people that you have 3 law offices in Winnipeg now, which is fantastic. It's nice to see the growth. At the foot of the Provencher Bridge in St. Boniface, over on Pembina Highway at Markham Road, and also at Sargent Avenue and Wall Street. You can, as I said, visit TLR Law's website, tlrlaw.ca, where you can subscribe to Philippe's newsletter, which is full of interesting stuff. And thank you again, Philippe. That's it for today. I really appreciate it.
Oh, thanks for having me, Adam.